so I fear that I will hit the roof. Mr. Menya's question on how do we hope to implement Chapter 6 in the light of the 2013 Constitutional Court decision to the effect that any person who has not been convicted by a court is still deemed to be innocent of that charge. First, I want to draw your attention to the fact that the checklist on integrity contains many, many boxes, and the box on criminality is one of them, just one. Let me give you an example. One of the other ones is academic qualifications. And as the Ministry of Education and the Commission for Higher Education has demonstrated recently, we have among us, regrettably, persons carrying around certificates that they have not earned. And therefore, one of the major areas of our concern in this integrity testing would be a basic one. Do you hold the educational qualifications that you claim to hold? And I think that that's very critical. Number two, there are very many people who have been convicted of criminal offenses relating to integrity. Again, we need to have the capability to have a database that is available to all these institutions. And we could go on and on and on as regards the checklist. So I wouldn't be very worried about the 2013 ruling. It affects a very small part of the testing we intend to do. How do we intend to work with the judiciary? I must say the judiciary has been extremely responsive. As you may know, the judiciary has its own election preparedness working group or task force. And that task force, I think, under the Honorable Justice Bogoli Msaga, is working to ensure that disputes are timeously resolved so that they don't interfere with the timelines that's set. I know that the Honorable the Chief Justice has spoken about this, actually this week, and you have quoted him widely on the media. So we are having very good cooperation with the judiciary, and I say no more about that. Finally, let me say something about Benjamin from the Star suggests that the executive may have interfered or has been said to interfere in certain institutions. I am not aware. It would be an election offense itself. It would be an integrity offense itself for any person in any office, any public office, to seek to interfere with this process, because that would be contrary to existing law on the integrity of public officers. And I would be very surprised if that were to happen. We intend, as I said earlier, to allow all offices to carry out their functions independently and in accordance with the law. We are not in a position to dictate to CID the list they can submit, or indeed to the registrar of the court on the list they can submit. That is their independent action. Finally, it was stated that the AG's office has come up with some laws that limit certain institutions in their operations. I'm not sure I quite understand which of these institutions you have in mind. But let me make this point, because I think it's an important one. We need to understand that the law-making procedures that existed before 2010 have ceased to exist. Parliament has its own independent and autonomous law-making authority. And many of the laws that we see today are government-sponsored laws, but there are many private members' bills that become law. Secondly, even where the government presents to the assembly government bills, the Assembly is obviously at liberty to rewrite those bills in whatever manner that the Assembly may deem necessary. So that among the many ills of the office of the Attorney General, this can no longer be one of them. It is only Parliament that can take responsibility for a final law, because it is Parliament that enacts law. I wish there was a way the Attorney General could have a power